To the 9th seminar of our second phase or tranche of the International PhD in Progress weekly seminar series, which is organised by the Global South Network. And a huge thank you to the founder and convener of the Global South Network, who also does all the organising of the weekly seminar series, Dr. Noman Riat, who's a lecturer in law at Leicester Law School. My name is Rhona Smith and I'm a Professor of International Human Rights at Newcastle University Law School in the UK. And I'm also one of the co-conveners of the Global South Network. So if you're not a member, feel free to pursue it, and we look forward to joining you in other activities as well. For this session, I'm joined by Dr. Marcus De Matos, who's a lecturer in the Division of Public and International Law in Brunel University in London. He will be discussing today, and he's an honorary member at the Institute of Brazilian Lawyers and a guest lecturer at the State Attorney's Office Professional Postgraduate School, where he teaches legal theory classes in the public law programme. And prior to that, he was the Director of Teaching Programmes at the Judicial School in the High Labour Courts in Rio de Janeiro. And he's also an advisor to the State Secretariat for Human Rights in Rio de Janeiro. So thanks to him in advance for his comments. And we also have, as is normal, a peer commentator. And today we have Mary Adeyemo, who's a doctoral candidate at the School of Law in Oxford and is also qualified as a barrister and a solicitor in Nigeria. That brings me on to our speaker today. Our speaker is Ikechukwu Ugwu, who's a PhD student at the University of Silesia in Katowice in Poland, and apparently it's getting colder by the day. We've just checked the temperatures in Poland. So he researches the accountability of multinational corporations and the rights of Indigenous peoples. So a very important issue. And in January 2022, he received a prestigious grant from the Polish National Science Centre. Previously, his master level studies were fully funded under the Commonwealth Shared Scholarship. He also has been called to the Nigerian Bar in 2015 and is a member of the Nigerian Bar Association as well as the International Bar Association. And today Ike will present thoughts on a specific part of his ongoing doctoral project. The presentation, as you can see from the slides in front of you, is entitled The Accountability of Multinational Corporations, the Rights of Indigenous Peoples in Africa, and the Extraterritoriality of the EU Green Deal. Now, for those that haven't joined us before, just a kind of refresher of what we do. We have the session being recorded, as we noted, and what we do is we have 25 minutes for the presentation. That will be followed by 5 minutes each for the discussant and the peer commentator, and then the remainder of the time will be available for anyone to ask questions from the floor. If you wish, feel free during the discussion and during the presentation to post comments in the chat function, and then I'll go through them in turn once we reach that stage of the proceedings. So a very warm welcome to everybody, a particularly warm welcome to Ika, and the floor is now yours.
Thank you, Rhona, for that introduction. I would like to thank Noman and his team for this opportunity to present my research. My PhD is on the African approaches to accountability of multinational corporations for human rights violations, specifically for the violation of the rights of indigenous peoples in Africa. I decided to present on this particular topic because it is a manuscript that I'm currently working on. So for the context, In the introduction, I will look at why the topic is important, and then I will look at the impact of multinational corporations on the environment and the relationship between indigenous peoples and these corporations. Equally, I will look at instances of extraterritoriality in environmental protection and examine the European Green Deals and as embodying these extraterritorial principles. Finally, I will analyze the challenges and then the conclusion. Why this topic is important. In an increasingly globalized and interconnected world, the impact of multinational corporations' activities in one country could be felt in another country or in another place in what is called the transboundary effect of environmental pollution. An example is the Trail smelter case between the US and Canada. Also, carbon leakage has increased where multinational corporations decide to carry out certain activities with potential climate change effects on countries or in countries other than where they are headquartered. Unfortunately, over the years, it has proven challenging to hold multinational corporations accountable for environmental and human rights violations, especially in Africa. This is notwithstanding the influx of numerous Western multinational corporations in Africa and then recently Chinese companies. So the aim of this research is to examine the likely impact of the extraterritorial application of the EU Green Deal on the rights of indigenous peoples and the accountability of multinational corporations. The research is mainly doctrinal, which allows for both descriptive and analytical examination of the EU legal instruments and tests. The first picture here shows a list of companies with the highest carbon emissions in the world. The second one shows the top corporate plastic polluters. While some of these companies have presence in Africa, none is of African origin. Now, I'm going to consider indigenous peoples in Africa and the relationship with multinational corporations. Going by the strict definition of indigenous peoples, there is an argument as to whether indigenous peoples exist in Africa. But I will point out that within the African Union, the socio-psychological approach to looking at the concept of indigenous peoples is adopted, where instead of giving a strict definition of who indigenous peoples are, the major characteristics that help to identify them, they are considered more relevant and constructive than giving a strict definition. One of these characteristics is that 80% of the world's natural resources is located within the territory of indigenous peoples. This is as confirmed even by the European Parliament resolution on biodiversity strategy. The implication is that multinational corporations find their way on the lands of indigenous peoples to mine these resources, and then indigenous peoples are the most negatively impacted by the activities of these corporations. In picture one, we can see the Endoro tribe in Kenya, who were displaced by their own government because of a planned game reserve to be managed by a multinational corporation. The second picture is a river which serves as the only source of water for the Kabwe community in Zambia. It was polluted by the activities of Vendetta PLC, a UK multinational corporation. The BBC once described this river as a river of acid due to the pollution. The third picture shows the impact of smelting of copper by Dundee Precious, a Canadian-based multinational corporation in Namibia. The activities take place in Namibia. The copper is imported from Bulgaria for smelting, notwithstanding the fact that smelting of such copper had been banned in the EU. Finally, the fourth picture is that of the popular Ogoni people in Nigeria. Countries have tried to extend their laws beyond their jurisdiction in what is called extraterritorial jurisdiction. Extraterritoriality simply means the application of a law beyond the territory of the lawmakers who made the law. As we know it now, extraterritoriality as we know it now could be traced to capitulation agreement, simply defined as a system of extraterritorial jurisdiction and power used by European states and the US in non-Western territories. The purpose of this capitulation agreement was to exclude the jurisdiction of local and non-Christian laws on investors from the European states and the US. For instance, the Sino-British Supplementary Treaty of 1843 established a British Supreme Court in China to entertain all matters involving British subjects who were working in China. Also, in recent times, to hold multinational corporations accountable, countries have equally tried to apply their laws beyond their borders. For instance, the US Alien Tort Statute allows a foreigner to sue in a US federal court for a tort committed in violation of the law of nations or of a treaty of the US. Many indigenous peoples across the globe, especially Nigeria and Ecuador, utilize this law to hold multinational corporations accountable. Unfortunately, the US Supreme Court has continued to restrict its applicability. In Kyobel and Shell, the US Supreme Court held that the presumption against extraterritoriality must be rebutted by acts that touch and concern the US before the Alien Tort jurisdiction could be invoked. Also, in Nestle and Doe, the US Supreme Court held that mere corporate presence in the US was not enough to invoke the ATS jurisdiction if all the infringement complained about happened outside of the US. Another extraterritorial mechanism for multinational corporations accountability is foreign direct liability, which is being developed within the European Union national courts. It allows victims of multinational corporations to sue for civil wrongs or torts and to seek for financial compensation from companies. For this, we have cases like Vendetta Longowe, where the UK Supreme Court held that a community in Zambia could bring an action against a UK parent company for environmental breaches committed by its subsidiary in Zambia. Similarly, in the 4 Nigerian farmers case, the Dutch Court of Appeal held that a subsidiary of a Dutch parent company was liable for oil pollution in some villages in Nigeria. Finally, the European Green Deal, but I will return to it later on. Before going to the European Green Deal, I would like to look at some challenges of foreign direct liability. One issue is that applicable law, since there is yet to be a European instrument that gives foreigners the standing to institute an action against a company for harm committed outside the EU. Courts, European national courts, struggle to find justification for assuming jurisdiction. In the 4 Nigerian case, a court of appeal in the Netherlands relied on various Nigerian laws, including the English common law principles, which form part of Nigerian laws. And then when you compare these to Shepherd and Friends of Earth, the French Supreme Court refused to apply or to rely on Congolese laws because the court found out that the company had political influence in Congo and that the laws in Congo were ineffective. If you look at this picture, you will see the former president of Congo, Joseph Kabila, being linked to Perenco, a company that was accused of committing various environmental pollution. And then again, we have the problem of no clear-cut enforcement mechanism. Now, on the EU Green Deal, it is a comprehensive and ambitious set of policy initiatives and legislative proposal introduced by the European Union. It was announced in December 2019 with overarching goal of making the EU climate neutral by 2050. It aims to transform the European economy into a more sustainable and environmentally friendly system, addressing both ecological and social dimensions of sustainability. It has some key elements, which include a zero pollution Europe, farm to fork, transformation of agricultural and rural areas. And when you look at this particular, the transformation of agriculture and rural areas, you will see Africa-Europe agenda as part of it. There are other elements. As noted earlier, the Green Deal provides an extraterritoriality regarding the application of EU laws beyond EU borders. But in the manuscript that I'm developing, I'm looking at two proposals or two laws. First, in June this year, the European Parliament amended the proposal for a directive of the European Parliament and of the Council on corporate sustainability due diligence. The directive would require companies to conduct environmental and human rights due diligence for their business operations. It applies to 4 categories of companies, but of importance is its scope of application on non-EU companies, which are subsidiaries of EU parent companies and non-EU parent companies with subsidiaries in the EU under Article 2. In Article 20, for instance, sanctions for non-compliance with the directive would include pecuniary sanctions, an obligation to perform an action, and suspension of the product from the EU market. In its definitional article, affected stakeholders are defined to include communities affected adversely by the activities or actions of a company or its subsidiaries. It further defines vulnerable stakeholders to mean stakeholders in situation of vulnerability, like indigenous peoples. So it recognizes indigenous peoples as stakeholders who are in a vulnerable state because of the disproportionate adverse impact of corporate activities on them. It also provides that companies must consult with affected stakeholders in order to identify and assess actual or potential adverse impact of their intended activities on the environment. The consultation must be genuine interaction and in dialogue. Once it is passed, it would require companies to fully respect the provisions of the UN declarations on the rights of indigenous peoples and other international law instruments on the protection of the right of indigenous peoples within the context of business and investment. In other words, even non-EU companies would be required by this directive to comply with the provisions of this law. It reiterates indigenous people's right to the lands and resources they have traditionally owned. Generally, as a soft law, the UN Declaration on the Right of Indigenous Peoples is not binding. The effect of this proposed directive, therefore, is that it would make the UN Declaration indirectly binding on European companies to respect and fulfill the right of indigenous peoples. In other words, it attempts to harden some soft law. Affected stakeholders, including indigenous peoples, have the right to notify or raise grievances and request remediation from the companies. Also, EU member states must establish supervisory authorities to supervise compliance with the obligation laid down in national provision adopted pursuant to this directive. The second strategy made pursuant to the Green Deal is the EU Biodiversity Strategy 2030. It is an essential part of the climate change mitigation strategy of the EU made as part of the Green Deal. The strategy aims to ensure that Europe's biodiversity will be on the path to recovery by 2030 for the benefit of people, the planet, climate, and its economy. Some communications and resolutions have been made to achieve this aim. For instance, the European Communication of 2020 emphasizes that the EU will launch the Nurture Africa initiative to protect wildlife and key ecosystems and to strengthen links between biodiversity protection and the role of indigenous peoples. It addresses all sub-Saharan African countries and goes beyond the protection of the areas. The idea is to promote a broader perspective on greening by involving the population and private sector actors. This initiative was actually launched in 2021. The European Parliament passed a resolution in 2021 also on the EU biodiversity, where they reiterated the right of indigenous peoples to land, the need for EU member states to ratify laws on the protection of the right of indigenous peoples, and the importance of indigenous knowledge in protecting biodiversity. There are many possible challenges to the extraterritoriality of the Green Deal in Africa. Regarding African countries' cooperation, in recent times, there has been an increasingly distrust on the part of African nations towards Europe. Some African states now prefer to deal with Russia and China instead of the EU. So there is a need for reassurance that these initiatives are for the good of all. On the political, geopolitical considerations, Professor Henriks and Gatti had this to say about the proposed directive, that the directive attempts to de facto impose Europe's values and political preferences on the ways business should be transacted practically in every other country, an aspiration that looks particularly precarious given the nationalistic spray in modern-day geopolitics. Also, Professor Clark accused the Green Deal of green colonialism. Clark has green colonialism is the practice of the global north making or taking decisions and actions in the global south under the pretext of benefit to the environment, and by using influence to make policies and developmental strategy by indirectly exploiting natural resources. For Clare, he warned that the essence of the NATO Africa, when there are still various problems with destruction, legal and illegal land grabbing, the militarization of natural parks, and human rights violations that happen under European conservation programs. Conclusion. As an ambitious initiative, the Green Deal, through the proposed directive, would expand the extraterritorial reach of EU laws and policies in areas that have always remained contentious, that is, rights of indigenous peoples and accountability of multinational corporations. The success of the Green Deal's extraterritorial efforts will depend on the EU's ability to navigate these complexities while maintaining its commitment to combating climate change. The Green Deal, through the proposed directive, would establish a substantive and procedural law on foreign direct litigations, and it will set Europe once more as an international norm creator. And then finally, the effect is that European laws and norms continue to shape the world, as they have always done. And African leaders should be more proactive in identifying problems that need to be solved, instead of waiting on the EU. Thank you for listening.
Very much indeed, DK, and well within the time zone as well. Yeah, a very comprehensive presentation, so thank you very much indeed. Without further ado, I'll proceed to then go to our commentator and discussant. And while I do so, encourage to also add any comments or questions that you might have in the chat function. Okay, and then or an indication they wish to speak. Then I'll come on to that afterwards. In the first place, I shall hand over now to Dr. Marcus De Matos, who is going to be our discussant for today. So you have 5 minutes. The floor now is yours.
Thank you, Rhona, and
Marcus,
thank you.
Sorry for the interruption. Eke, may I ask you if you stop sharing the slide so that we can see Marcus clearly?
Okay.
Marcus, please go ahead. Sorry for the interruption.
No problem. Thanks, Norma, as well. So thanks, Rhona, and thanks, Ike, for this interesting presentation. I have sort of two level of questions for you, and I think some of them you answered in your conclusions here. So, but I'll throw them at you as anyway. So hopefully they might help you reflect on a few of the propositions you made. I'm not entirely sure how far you are in your PhD. So some of the questions here might make more or less sense depending how far you are. It's the first or last year that you're doing this. But you know, I'm not, and also I'm going to make very clear where I come from. So I'm not an international lawyer. I'm very skeptic sometimes in international law and international courts. I work with human rights, but I tend to focus on national and regional issues. So the first thing that comes to my mind when I look at your analysis of the Green EU deal is, you know, you talked a lot about, in the beginning, you talked a lot about accountability of transnational and multinational corporations. But I wonder, you know, and you make some strong assertions about the result of how multinational corporations interfere with indigenous rights, indigenous land issues, which I totally agree. But I was wondering, like, you know, if you have if it would help you to define what kind of court cases you're looking at. You know, when you're thinking about you know, multinational corporations being taken to courts in African countries because of indigenous rights violations, for example, are we dealing with criminal court cases, human rights level violations on international level, corporate law, tort, environmental law issues? You know, what kind of court cases are you looking at? And I think this is relevant because the way you are, the way you outline the issue, kind of make us, at least for me, make me think of the African judiciary generally. Like African judiciaries are not independent or are weak, and I don't believe that's the case, at least in a few countries that I know. So I was wondering, like, you know, if you would frame your problem more specifically in terms of courts and kinds of legislation and law that would, you know, disciplinarily inside law, if this would help us understand the issue between transnational companies and national countries better here. And I think this kind of would also lead to a point where something that I think is not necessarily the perspective you're adopting here, but I would like to hear when I read your abstract, I was wondering, like, where are the perspectives of the indigenous peoples here? You know, because it seems to me that most of your work is focused on the perspective of you know, the courts or the EU, you know, these abstract entities, and I was wondering if you could give more body to the actors here, like who actually are the actors. You only talked about indigenous people to say, you know, the concept, or also how indigenous peoples are conceptualized for these cases, and I was wondering if they could have more body in your research, and this could lead to, for example, one result that could come out of your research is on, like, strategic litigation, like what should be the strategies for these groups or the companies who are dealing with issues like that to you know, what they should focus on in terms of litigation. And on top of that, and then I'm going to raise some more methodological issues, which are I think, depending on how you frame your question and these issues that I mentioned here, are you focusing more on court cases? You know, what kind of court cases? Are you going to collect data from interviews of these, you know, these judicial actors that are there, or the multinational companies, or are you going to focus on what seems to me to be your strategy? You're focusing on statutes or international treaties, and I wonder if because you raised very timidly, but you raised the issue of the influence of these companies in the national scenario and the court systems, perhaps, but you didn't talk about lobby. You didn't use the word lobby, and I was wondering if lobby is something that should be dealt with and thought about in framing your problem, your research, and then and also on top of that, still on the methodological side of the questions, you know, how do you plan, or are you going to select the cases, the countries, the indigenous groups, or the multinational corporations that would be relevant to the EU deal that you're analyzing? You know, like how would you justify, or do you have a justification for selecting such cases and companies and not others, or countries, certain countries? And then finally, and I think you responded to that in your last comment, in your conclusion, like, do you believe that regional and international agreements could actually produce better results for the indigenous groups or for the multinational companies than national court cases on these violations of indigenous people's rights? That's it. I hope that helps.
Okay, thank you for a long list of questions and comments. So I'll hand over to Ike to respond, and then we'll come on to Mary. Otherwise, it's a lot to keep remembering or to write down.
Yeah, thank you, Marcus. I think that was a lot. Yeah, the first one was the kind of court cases, criminal cases. Yeah, the issue with multinational corporation is that when you look at their status under international law, they are not yet recognized as subjects of international law. And then it is a big problem. And when you consider criminal cases, recently there was the definition of ecocide, and then the recommendation that ecocide should be made part of the Rome Statutes of the International Criminal Court. But I have an issue with that, because when you make issues like corporate accountability part of international criminal, it makes it more difficult for people to prove, because for you to prove a crime, you have to prove two elements of the crime: the actus reus and then the mens rea, which is very difficult to prove, especially regarding the status of multinational corporations, as they are not yet subject of international law. But for my research, this presentation is just a manuscript that I'm trying to develop. It's just a tiny part of my PhD. So I have many other issues regarding the perspective of indigenous peoples. When you look at indigenous peoples in Nigeria, the Ogoni people, you notice that they have moved away from Nigeria. They are now they went to the US, and then the system in the US is no longer that functional. They now came to Europe. You know, they keep on moving around the world seeking for accountability. This is because the system in Nigeria is not favorable to indigenous peoples. In 2005, there was a decision by the Federal High Court in Bemere and some communities in Nigeria that gas flaring in some communities should be stopped by the government. But the government ignored such orders, and then they kept on flaring gas, meaning that when a court gives a decision, it's left for the government to either implement it or reject it. And then the judiciary doesn't have enforcement mechanism on its own. They rely on the government to enforce their judgment. So if the government is not comfortable with the judgment of the court, they will just simply ignore it. And then the court doesn't have any power to do anything. Yeah, regarding lobby, I think it should be more of corruption, not even lobby, because in Africa we have very corrupt leaders, extremely corrupt. I showed the case of the Congolese former president. His family, his daughters were into the company accused of environmental pollution. So he couldn't even hold the company accountable for what they were doing. And then some of these companies, they come into Africa, they look for politicians, to get as shareholders, so to have a political influence on how the laws are made. And in my PhD, I look at indigenous peoples from different parts of Africa, from the western part of Africa, eastern part of Africa, and then southern part of Africa. But for this presentation, I just looked at 4 because their cases, the one in Namibia produced the case in the UK, the Vendetta case, which was delivered 2 years ago. And then the 4 farmers in Nigeria, the Ogoni one, is a popular one. That was why I chose it. And then the Dundee in Zambia, I just decided to choose this one because of their impact and then the cases they have produced over time. I think I've gone through some of the questions you asked.
Yeah, I think just the methodology.
Yeah, the methodology.
You mentioned doctrinal in your presentation, but Marcus had just queried if you're using other methods as well.
Yeah, so I'm just choosing a doctrinal because I will not be interviewing some of these indigenous people. So I'm just considering judgment of courts, legal instruments, and then policies.
Okay, thank you very much indeed.
Ike.
Thank you.
Okay.
I'll now hand the floor over to Mary, who is our peer discussant. And Mary Adeyemo, the floor is yours.
Yeah, thank you very much, Rhona. Thank you for your comment, Marcus, and thank you to Ikechukwu for the very lucid and brilliant presentation. My question is sort of related to what Marcus has already asked, but my own is more focused on the enforcement and implementation. So given the interplay of international law and state sovereignty, the extraterritorial international treaties, the question is, how do we actually enforce this? And which I think is a big issue. So the fact that, again, we keep saying that in Africa or in Nigeria, for example, the problem is not the lack of laws, but actually the implementation of those laws. So what aspects of your work, or how do you propose implementation? Again, giving Nigeria as an example about the domestication of some of these international principles. So if a law is not domesticated, even if we have, consented to it, or we're party to that international treaty, doesn't really have any effect on Nigeria. So what's your plan towards the, implementation and enforcement of this Green Deal in Africa, especially that you have noted that our politicians are extremely corrupt? What is the implementation plan? If your research is looking at the implementation plan, and what do you propose? Thank you.
Yeah, thank you, Mary. I think this your question now reminds me of another question by Marcus on which law should be preferred in terms of enforcement, whether regional or national laws. When it comes to issue of enforcement, I think for this European Green Deal, it will be very effective because Europe always takes things like this very seriously, unlike some African countries. But when this the directive becomes effective, it will have the impact on some companies like Shell in Nigeria, and then I think they will become more responsible. Regarding also implementation of some of these laws, yeah, I agree with you. Some of the laws we have consented to, the international laws, have not been domesticated in Nigeria, making them almost useless in Nigeria. So it is now left for us Africans to, insist that our politicians should make sure that these laws become effective, because without us Africans, they won't do anything. So yeah, enforcement is a very big issue.
Do you have any other questions or points, Mary?
No, I mean, not a question, but maybe just, you know, a form of thought, because again, we are researching to find solutions to existing problems. So maybe in your research, you may want to propose that the Nigerian Parliament, you know, sort of make a distinction between self-executing international treaties and international treaties that should not be, you know, self-executing, if you get what I mean, so that even if the EU has taken a, you know, bold step to make this Green Deal that will be very beneficial to the African community, we can tap from this benefit because the legal framework doesn't even allow its existence or it to manifest. So it may be a point to note as part of your recommendations for the legal structure, the legal framework to be reworked, if we don't just want to assume all laws to, you know, be immediately self-executing before, you know, we want them to be domesticated first before they are implemented. But there are certain things like this EU Green Deal, you know, which is very beneficial to us. So, I mean, if I were to be the CEO of Shell or to be the CEO of any oil company, I'm not moved because, hey, again, like, let them do the Green Deal, let them do whatever. We are going to implement it in every other country, but in the African region, because they got nothing on us, you know. When we go to court, it's a court of law, not a court of emotions. What does the law say? You know, the law hasn't said anything. Have we gone, you know, against, except we want to then introduce international law? And like my university lecturer was saying, international law is a dog that can bark but cannot bite. So we can just keep barking at them, but we can't bite Shell. We can't bite these oil companies if the law doesn't provide us to bite them or give us the allowance to bite them. So you may just want to include that as part of your recommendation. Thank you.
Yeah, thank you very much for that. But I think even when the laws in Nigeria, the constitution is changed to make some international laws like self-executory in Nigeria without having to go through the process of domestication, it is still left for Nigerian government to decide on implementing it, because we have some of these laws we've consented to and then we have domesticated, but yet Nigerian government doesn't implement them. So what do you do?
Yeah,
so yeah, thank you very much for that.
Challenge.
I will look at it. Yeah.
Okay, thank you very much indeed. I'll now turn to questions from the floor. We'll go through the ones in the chat first. Anybody else, please feel free to comment in the chat or to raise your hand, and I'll try and keep watching and no one will pull me up if I miss anyone. So please do so. But first of all, the first comment or question we have is from Gifty Brew Mensa. Do you want to speak to this or do you want me to read it out?
Oh yes, you can read. I think it's a suggestion that I was trying to put across.
Yeah, you can speak if you wish. It was just I wasn't sure. Okay,
Ikechukwu, well done.
Thank you.
It was a good presentation, and I always say you guys inspire me, so that when the time comes, I should be able to do well. So I was just saying that given the challenges we have discussed, I mean, at length with Mary and all that, you know, these laws, they can back, but they can't bite, for instance. I was thinking that we have to look at preventive measures in the first place. In this case, these multinationals come around based on some form of agreement that we do sign with them. So much as we may have corrupt leaders in place, if we build institutions by putting in some measures in the agreement that these people sign, they should be able to, you know, have a fair idea of what is in store for them. And then in that way, we can protect the indigenous people. But it all boils, you know, it goes back to the enforcement issue. So yeah. I don't know how you can incorporate that if it's possible. That's my view. Thank you.
Thank you, Gifty. I think it's possible, but the problem, like we have already identified, is not the problem of laws. And recently, not quite recently, in 2016, Nigeria and Morocco signed a bilateral treaty agreement. And then the treaty agreement is recognized as a new form of bilateral treaty because it incorporates obligations on multinational corporations to respect human rights and then to protect the environment. These provisions are, or we are not in previous bilateral agreement. But yet, some of the Moroccan corporations in Nigeria don't keep to this agreement. So it's still left for the government, responsible government, to enforce these laws and agreement.
Thank you.
Okay, thank you very much. We've got one hand raised, but we've still got another question to go first, and that's from Asmahan Mizuya. Asman? No?
Sorry, I posted a couple of things there. I'm not sure
Yeah,
which
do you want
one
me
to
to,
start
just if you
with.
wish to speak to it rather than me read it out, that's, or I'm happy enough to read it out, but if you want to speak to it, you can.
You can just read them over, please. Yeah, just send a couple of things there. No problem.
No
Thank
problem.
you.
Right. The first comment was that our domestic laws are also largely influenced by external Western power, especially in the area of green criminology and corporation. And as you'll see from the chat, there's been a bit of a debate between Asman and also between Diane Levin, who's had to leave, but has had an extensive comments as well. So you might want to look at that, who's been working in various issues in Southern Africa too. And then, as Mohan has said, that they think the power balance is an issue that needs to be addressed first before going on. Okay, so if you could look through that, if you get any comments on that in the chat, and then we'll come to the next question after that.
Yeah, sorry, I just add up to that one on my.
Yeah, please.
Comment. Yeah, there's also element of not just balance and power and balance, but also many international agreements, or when we ratify a certain international legislation, most of our countries in Africa, we do it under a certain influence. So for example, we ratify the deal because we'll get a cheap loan. So we're always working under a certain, I don't know, be a duress or a certain influence. So it's very hard to kind of looking on how our domestic law could work independently and reflect the domestic issues. So we always ratify something that probably we should not, or we can do it in a different ways. And that's why we find it very kind of hard to implement. Implementation doesn't reflect because we were not mirroring. We have not done it through the very social construction on how what the society needs and how can we able to implement that. So we are not mirroring the needs of the society itself and our capability to implement what we have agreed.
Yeah, that's true. Because some African governments, some of our leaders are under the influence of some powerful countries. And when you look at what is happening currently in Africa, you see a shift from the relationship we have with the West to China and then Russia. So I wouldn't want to comment on the appropriateness of this shift, but you wouldn't blame African leaders for doing that. And then again, I have a problem with whenever we try to blame some certain powerful countries. We should be more responsible. I mean, African leaders. They should be more responsible. They should know and then identify laws that will be detrimental to their countries and then refuse such laws. And then now that they have this Green Deal, why didn't African countries come up with something to protect the rights of indigenous people? Even though we have them, but implementation is an issue. And so when this Green Deal becomes fully effective, you will still find us trying to blame the powerful countries for doing this. So we should always be proactive and then identify areas that need to be solved.
Thank you. We now have a question from the floor from Gilda Jallo. Gilda?
Yes. Thank you very much, Ikechukwu, for the brilliant presentation. My question is, you focus on the Green Deal as a potential solution for the violations that goes on. My concern is there is an increasing number of companies operating in Africa which are not multinationals. In other words, they are local based, but they have a wide influence or wide area of operation that sometimes, in fact, they committed most of the crimes compared to multinationals. And this Green Deal, is not going to capture these local or domestic companies. So the violations, whether it's pollution, human rights violations, they will still carry on because these companies, they are not domiciled in the EU. So EU have no controlling influence over them as compared to like Shell, which are multinationals. So it's very difficult to see how far there is a very comprehensive solution to the problem. However, I think if the EU actually put their own force behind the Green Deal, it can make an impact. But I'm just looking at this aspect of the domestic companies, which actually they will carry on to commit their atrocities. Thank you very much.
Yeah, thank you, Jallo. Yeah, you are correct, because the Green Deal, especially when you look at the proposed directive, it deals with some companies, for instance, European companies that have subsidiaries in Africa, or African companies that have subsidiaries in Europe. So there is a possibility that some companies may not be affected by this directive. For sure, it is. But this also goes to the definition of multinational corporation. For me, once a company has influence or carries on operation in more than one country, it qualifies to be regarded as multinational corporation. And then when you find some of these companies in Africa, they were established by some powerful companies as subsidiaries, and then the parent company tried to remove themselves from the activities. So when you look deeply into their shareholding, you will still find some of these powerful companies having shareholding in those companies. But I agree with you, definitely some corporations won't be affected by this Green Deal. And then it's left for us to decide on what to do with them.
Okay, thank you. And we also have a comment from Asmahan that coming from Tanzania, they also are suffering in the same way as you were outlining earlier. And again, I understand that, having heard some, then it's not only Russia and China, but also UAE, I think, is impacting in some of the territories as well. So there's lots of challenges. We're almost out of time, and I don't think there's any other comments in the chat or any other hands up. So I'll just start wrapping up. So firstly, if you'd all like to join me in thanking very much indeed Ike for a fantastic presentation, a really interesting subject and all too horribly real and problematic for so many people. So thank you very much indeed. Indigenous peoples, what my PhD was partly on, so always something I look at. So thank you very much, and also a huge thank you to Marcus and to Mary for acting as our commentators and discussants. That's very valuable. And a thank you to everyone who has attended and listened in. And can I also just extend an invitation to you that next week at the same time, same link and Teams and everything, we have our next speaker. It's December already, so it's the 6th of December. So Cassandra Silcott, who's a doctoral candidate at Leicester Law School, will be speaking on what is the impact of the Windrush scandal, a case study reviewing the social inequalities experienced by the Windrush generation. So hopefully you'll be able to join us next week. Thank you very much again.